I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So we've got 2 DWS files, correct?
You over and who's in the board status, but I think we're here on this motion hearing.
Yeah, so one file's a money issue, the old one from December 2016. That's a drove while license suspended. The file shows you owe money.
Yes.
Right, all right. So we'll talk about that one. All right, and then you filed a motion on the case from November 2025, correct? All right, give me a minute to look at the paperwork. Okay, I did see Mr. Blade's motion. I did have a chance to see that, read that one already. So I'm going to read the people's response. Okay, I've had a chance to review. So anything you want to add to your written brief?
It's showing that there was no personal jurisdiction when the court back the authority to make a judgment or default judgment.
You're talking about the Monroe case?
Yeah.
Okay, go ahead.
They lack jurisdiction in order to make that case or make a judgment for.
Anything else?
I can't find an easy to prove service and collective. I saw people service from we heard about.
Just to be clear for the record, we're still talking about the Monroe case?
Yes.
Okay, go ahead. Right, right.
To ask for proof of service that were unable to provide it.
Right.
They told me that it was for the sheriff. So I go to the sheriff's office to ask for proof of service because that's their reason.
Right.
Because I didn't receive the notice to appear in court, so I had no idea that we were trying to get me again.
Okay.
And going forward, I go to the sheriff's office. I ask for the proof of service from the sheriff's secretary. Bird. I'm not sure that they were the position or if she's at line of test. But she noticed that the ticket has the officer's name, which happens to be down currently the 20. He come out and spoke to me. He said, I don't remember this ticket. I don't even believe I was, I don't even believe I was on that shift at this time. A few things that he meant to. So I wasn't prepared for this. I was studying everything supposed to be clear. When he spoke to me, I took what he said and I said, okay, maybe I can get him to fill out an affidavit.
Right.
You know, the things that I'm not asking him for anything in my favor, just what you recall, all I want. He didn't respond in time. He mentioned that he would have no problem speaking to the court here for the last case. But I didn't receive that response in time to go to the court. But he went into my motion. The officer said he believes that I did have insurance, but I was a pretty sure force. I didn't know the case with the court to be there.
Okay. Anything else? Anything to add to your written response that I just read?
No, yeah, the court is well aware that this court doesn't have any jurisdiction over a no proof of insurance citation that was issued by Monroe County Sheriff's Department in 2005.
All right. Mr. Blade, I've got a question for you. Do you know whether or not the Michigan Secretary of State listed you as a valid driver on November 29, 2025?
No, I have no idea.
Okay. So if I told you the Secretary of State record showed you were suspended on the day that Officer Hayden stopped you, you would have no reason to take issue with that fact? If I told you that your driving record listed you as a suspended driver on November 29, 2025, you have no argument one way or the other whether or not that's the case.
One more time.
No, that's all right. I don't want an answer if you don't understand the question. If I told you your Secretary of State driving record showed you as a suspended driver on November 25th of 25, would you have any reason to deny that as factually correct? Okay. All right. So I'm going to deny your motion for two reasons. Number one, his actions are based on what the Secretary of State says, not what the Monroe County Sheriff's Office says. B, I don't have the authority to do what you're asking me to do, because if I understand the situation, your Monroe case has been completely adjudicated in Monroe. They've left that on your record. I don't have the authority to change that record.
That's not what my motion is asking, but I'm only asking you to recognize the jurisdiction. That's all I'm asking.
I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So my ticket, the Huron Township ticket, is a perfectly valid ticket moving forward.
But the jury,
Gather your thoughts. I'm not in any hurry. These kids want a show.
default judgment issued without prior notice can be seen as a violation of the party's rights to due process.
Absolutely. Absolutely. But not by me. I can't override the Monroe Court. Now, I can take all this into consideration when I sentence you on this file, but I can't set aside what happened in Monroe. Okay. Okay. Are you just seeking to mitigate your damages here? Are you just seeking to mitigate your damages in this court based on what happened in Monroe?
Monroe is the reason I'm here. So
Absolutely.
we can't separate the two because it's the Monroe charge that got me of driving without.
Right.
They got my license.
Right. I understand that.
I did insurance, which I absolutely did. Would you like to see that?
No. I'll for today's argument, I'll take your word for it.
I did actually have insurance,
Right.
but I didn't have an opportunity to defend, to show the court that I had insurance. So going to jail and then to prison right behind us, when I come home, I'm trying to get my life together.
Okay, well, first of all, I can't speak from personal knowledge in Monroe, but every court I know of on a civil infraction, they don't send a notice out on a civil infraction. The ticket is your notice that you've got a problem you got to deal with.
But I didn't receive it. I went to jail that night.
So they never handed you a ticket?
No.
Okay. Well, then you got a problem, but I can't fix it. I don't have the authority to fix it. If we have a trial on today's DWLS case, as prosecutor, she's going to have to prove to me that on November 29, 2025, your driving privileges were suspended in the state of Michigan. And she's going to have to prove to me that you were driving a vehicle on that date in Huron Township. If she proves that to me, I'm finding you guilty of drove while license suspended, revoked, or denied. The fact that the Secretary of State shouldn't have suspended you does not change that at all. You were suspended. Whether or not Monroe screwed up or they didn't screw up, you were suspended. So I'm denying your motion. Okay? I'm assuming we can have some pretrial conversation?
And you're,
Okay.
Mr. Blake, if one wishes to plead to the drug license suspended, I will dismiss the two remaining.
And I don't even have the remaining charges, so are they already in default? Or did I just not get the files?
Vehicle and another misdemeanor registration title among the.
Oh, I'm sorry, I was looking for civil infraction. Okay, all right. Do you want to avail yourself of that offer? She will dismiss 2 misdemeanors if you plead to the drove while license suspended. So the misdemeanor unregistered vehicle and the plate or registration violation misdemeanor, right, those 2, would be dismissed if you plead to the drove while license suspended, revoked, or denied.
Think that over.
The hallway is yours. Yeah, go take a minute. That's fine. Why?
Research.
You no objection to another? We'll adjourn it. Oh, I don't care. March 12, give you enough time?
Yes.
Okay, so Heather will prepare a notice on that one. Now, as to the December 1, 2016 file, our records show that you owe $840. Are you in a position to make some kind of a payment plan on that?
But I have any money to pay. I currently don't have any money to pay.
All right, you're confused. You don't have any money today?
Yes.
All right, but you could commit to some regular payments and make them. How much, how often, when do you want to start?
I think about financial. But I don't make very much money.
I need you to make some kind of commitment today if you can. You don't have to start it today.
It shows that.
Okay. How much?
Even if it's just one,
No, I'm not paying a clerk to process a dollar payment. But I got to get something going. How's this? When's the last time you worked?
I don't put
Where do you work?
forward.
Walmart? Cormart, what do they do?
They,
Okay, full-time job? Okay. Can you pay $50 a month? Start when? First Friday of March is the 6th, and that's 2 weeks out. Can you do that? 50 a month. We'll always take more, so if you want to pay extra, $50 a month, starting March 6th. Yes? Agreed? Okay.
What unfolded in this hearing is a perfect example of the difference between arguing fairness and arguing legality. The defendant believed that because the original Monroe County case may have involved mistakes, improper notice, or due process concerns, the later suspended license charge should automatically collapse with it. But the judge explained a very important legal reality. A driving suspension remains legally active until it is officially removed by the proper authority. That means even if the earlier case was flawed, the Secretary of State still listed him as suspended on the day he was pulled over. And for a DWLS charge, that fact alone is enough for the court to proceed. Throughout the hearing, the judge actually remained patient and tried to separate the defendant's frustration from the narrow legal issue in front of the court. The defendant kept returning to Monroe County, arguing that he never properly received notice and that the suspension should never have happened in the first place. But the judge repeatedly clarified that this court did not have the authority to overturn another court's finalized decision. In other words, even if Monroe made mistakes, this judge could not erase that suspension from the driving record during this hearing. The only question here was simple. Was the defendant officially suspended when he was stopped? According to the state record, the answer was yes. Another key moment came when the judge explained how traffic and license laws work in practice. Courts and police officers rely on official state records. Officers are not expected to independently investigate whether a suspension was fair or unfair before making a stop or issuing a citation. If the Secretary of State database says a person is suspended, then legally that suspension is treated as valid unless another court changes it. That is why the judge said multiple times, whether or not Monroe screwed up, you were suspended. It may sound harsh, but legally it is a very direct principle. At the same time, the hearing also showed the court attempting to balance accountability with practicality. Instead of immediately escalating punishment, the prosecutor offered to dismiss 2 misdemeanor charges if the defendant pleaded to the suspended license offense. The judge also worked with him on setting up a manageable payment plan for older court debt rather than demanding immediate payment in full. So, while the defendant focused heavily on jurisdiction and procedural arguments, the court focused on resolving the actual legal exposure in front of him. In the end, this hearing became less about conspiracy or jurisdiction and more about the limits of a court's authority. One court cannot simply undo another court's finalized ruling during an unrelated proceeding, and when a person continues driving while officially suspended, even if they believe the suspension was unfair, they still risk criminal liability until that suspension is formally corrected through the proper legal channels.